No more than 10 minutes. Senator Steele-John.
Thank you, Chair. All right, so let us move now to the legislation introduced by the government on the 17th of March. As you'll be aware, there have been concerns flagged by the community that the legislation as drafted does not adequately provide protections for individuals disclosing systemic forms of information in relation to violence, abuse and neglect and exploitation. The particular examples that have been put to me, and I think should have been provided via my office to both the department and yourself, particularly relates to situations of an individual wishing to disclose information, speaking to potential policies that have had discriminatory effects or in otherwise been part of a context which enabled the abuse of a cohort. And of course this is particularly important because systemic violence, abuse, neglect and exploitation is arguably one half of the work the Royal Commission has to do, with the other being individual work. Now my office has provided to your office some suggested wording changes which would clear this matter up. And I'm just wondering if you're able to give me any indication as to whether the government will accept those changes and enable the legislation then to be passed.
It's my understanding that the government does not intend to adopt the changes that you've proposed for the reasons that we have discussed privately. The bill as drafted sets out, I think it's 4 conditions that need to be met for particular information to attract the additional privacy that is provided for by this bill. It is the view of my office, myself indeed, that the situations that you describe will be captured by the bill as currently drafted. Now, I know you and I have a difference of opinion on that. It's also important to remember that it's quite an unusual thing to provide for privacy protections of this intensity for a Royal Commission, and that's because Royal Commissions are about bringing sunlight into difficult and difficult matters that need to be exposed. There's an attempt made here to strike a balance between the important need to protect the dignity and the privacy of people coming forward without going so far as to make it so that none of the information that's supplied can really be used. It's the government's view that the bill as drafted gets the right balance in ensuring that people who have experienced terrible things do not have that dignity undermined, but at the same time making sure that the information provided to the Royal Commission is able to be used to meaningfully affect recommendations that can then be implemented to affect change.
The problem with that, of course, is that the terms of reference of the Royal Commission that establishes it makes multiple reference to systemic violence, abuse, neglect. And the very nature of systemic violence, abuse, neglect is that it can and often is disclosed by individuals that are not themselves directly affected by that violence, abuse, neglect, and to whom they cannot pin the impact of that abuse or neglect to an individual themselves. So a teacher, for instance, may have an understanding of an educational department or a school department's policies and processes that may discriminate against disabled children, either explicitly or implicitly. Now, that policy does not directly affect them, and they may not be able to directly identify an individual affected by that discriminatory policy. That is a piece of systemic abuse, a systemic problem that must be investigated, and the concern is a well-founded concern, in my view, that the legislation does not clearly enough articulate that this is protected. Now, your office has indicated to me that you're willing to consider amendments to the explanatory memorandum in order to capture what you are articulating is the intent of this legislation. I would put it to you that if there is work to be done in the EM, let us simply state it clearly in the body of the bill itself. because ultimately this is a question of the public's confidence, and it is directly a question of the public's willingness to extend trust to a government, particularly an Attorney General, to have created a process that properly safeguards whistleblowers, potentially giving evidence as to discriminatory, abusive or exploitative policies and practices within government departments. Now, I would suggest to you at this particular moment that trust from the public is at a historic ebb. And so I would ask again, and maybe I'll rephrase it, because this is what I'll do, quite frankly, if we can't come to an agreement, I'll be banging an amendment into the Senate to get this done. Are you saying to me that the government will not be...
Please confine your contribution to questions only, please.
Sorry?
You need to direct your questions to the witnesses and not any other commentary, please.
I am.
Okay, thank you.
Coming to yes. No, I'm coming to a question. The question is, should the amendment be put before the Senate? Would the government's intention currently be to vote for or against that amendment?
Senator Steele-John, we judge amendments once we've got them in front of us and we can take a look at them. But let me say this about the example you've provided of the teacher. The Commissioner's approach and the consultation with the Commissioner about this amendment was to the effect that it was necessary to provide confidence to people who had themselves experienced terrible things. The bill does just that. The example of the teacher, who is not themselves a victim but who has information to supply, is in a different situation to the person who has experienced trauma themselves, and I would suggest can be adequately protected by the protections that currently exist. So there's nothing standing in the way of a conscientious public servant or teacher or worker who has observed systemic problems from being able to come forward and provide evidence. The amendments proposed by the bill are all about giving people who have had terrible experiences themselves the confidence they need to come forward, and it's the product of consultation with the Commissioner, and we believe it gets the balance right between sunlight and the need to protect the individuals involved from undue trauma.
Of the 8 national disability advocacy peak bodies that exist and are funded by the federal government, which has the department consulted in the drafting of this legislation? I'll take that on notice. And could I just then go to a letter that was written to the government on the 30th of October by Chair Sackville, followed up by a subsequent letter on the 14th of December, requesting a 17-month extension on the reporting date of the Royal Commission. It was noted in that letter that impacts such as COVID-19 had affected the Commission's work, as well as the scope of the terms of reference being very broad and requiring deep investigation, coupled with the absence of this legislation and the chilling effect that that had on the community. Now, as of the 10th of March, the government had not responded to that request. Has the government now responded to that request?
The government is considering it very carefully and acknowledges the impact of COVID and will, in due course, provide an answer on that matter, but it is being very seriously considered.
Can we please get a little bit more specific than in due course?
Well, I don't think you'll be waiting a very long time.
We have a year left, like a year left on the most historic investigation into this issue. Mr. Dodson knows what this is like. This is a painful process, and to think that we would not be able to get to the end of that investigation properly, particularly since you've spent 2 months drafting this thing, is incredibly concerning for my community.
Senator Steele-John, if I could just ask you to not
again,
make
can we come a little bit more?
Please, this is your last question.
Sorry, I just can't hear.
Chair.
Last question.
I I'll put my cards on the table.
Can I
with you.
answer the last question, or are you still going on the same
Well, no.
question?
I'll get. The chair's directed me to come to my last question, and
Right,
this is my last question. I am concerned that the government intends to respond to this request with an extension of around 6 months. I'm deeply concerned by that because that covers only a little bit more than half of the time lost by the Commission due to COVID-19, let alone taking into account the impacts of the absence of the privacy protections and the broader impact on the community of COVID-19 when considering how to tell our stories. So are you able to confirm here that the government will not be offering a 6-month extension, a wholly inadequate time period, to account for the impact the Commission has experienced?
I'm not going to preempt the government's decision. What I will say to you is that we are sympathetic to the concerns associated with the impact of COVID-19, though I would suggest to you that if COVID-19 is the only matter we were dealing with, 6 months is not an unreasonable reflection. It's also important to note that while the matters being dealt with by the Royal Commission are very serious, and we wholly acknowledge that, it's also a quite long Royal Commission in comparison to other examples over time, and it is not unreasonable to place some limits on the ability of a Royal Commission to do these important tasks. It's not an indefinite exercise. It's something that we need to get to the point of recommendations so that we can implement it. We really want to make sure that we are getting the policy change that's necessary to improve the lives of people who are experiencing terrible things. And so there's a balancing exercise involved, and all of those considerations are being taken into account.
Thank you very much, Senator Steele-John. I now give the call to Senator Carr.
Thank you. I'd just like to follow up some questions that you asked, Madam Chair.